May I please, Lordship? My Lord, two items are listed of mine. Item 27 may kindly be taken after 2 weeks. 30 I will do.
But this 27 is a review matter. Let us take it up, then we'll see.
But
Since,
I could not go through the record due to some personal difficulty.
Okay. Give me fixed it after 2 weeks. Item 27, both sides are represented. List on so-and-so as paid for by land counsel for the petitioner.
Obliged.
May it please your Lordship, item number 25, Lordship, the admission column. If possible, Lordship, kindly upgrade the method.
Okay, we'll try to.
Obliged, Lordship.
May I please, your Lordship, my Lord, I beg to mention item number 21, my Lord. My Lord, this matter may be taken up next week, my Lord, due to my some personal problem, my Lord. Not item number 21, my Lord.
21. Okay.
Yes, my Lord.
After 2 weeks.
Highly obliged, my Lord.
May it please your
My Lord,
Lordship.
there is interim, my Lord, regarding shall not be deported, my Lord. That may be continue if your Lordship.
21. Okay. Just check up and then it might extended. Before
Highly obliged, my Lord.
check the last one.
Highly obliged.
May it please your Lordship. So I beg to mention item number 10, your Lordship.
Item
10, your Lordship.
10.
Yes, Lordship. Kindly pass over the matter for the day. We list it next Wednesday because we have certain difficulties this week. Next Wednesday is 23rd. List on 23, 7/2025 as paid for by the counsel of the petitioner. Obliged.
My lord, in item 22, we filed an affidavit yesterday, my lord. Same may be called for.
Okay.
Obliged.
Repeat your lordships. Your lordship, I beg to mention item number 28, your lordships. I think they said after a week, your lordship. There's some personal difficulty.
This is IA for?
For bail, your lordship.
Hmm?
For bail, your lordship.
Okay. After 2 weeks as paid for by the counsel of the petitioner. Applicant. Okay.
Much obliged.
May it please your Lordship. Lordship, prayer for listing.
It come next week, not this week.
May I please, my lord? Item number 29, my lord, with concern of the other side, may it be adjourned for the day?
What is this IA for?
WPC.
Okay, after 2 weeks as paid for by the counsel of the petitioner. Applicant.
Obliged.
Item 1 for motion.
May please, your Lordship. Opinion, my lord, of page 57, annexure 20, my lord.
Page number
57.
57. Where is that refugee status certificate? Where is that?
My lord, page 15, my lord.
15.
1 5, my lord. Annexure 1.
5 copy and 16 is a vernacular.
You have a good copy, is page 16, we can't read.
Yes, my lord. Good copy is not my hand, my lord. You know, the record, my lord, I think probably it is legible. Record was called for record is. Hello.
Yeah, I said, no, no, no. We will have to get it, we can't read this also. This and your page 16 is same.
One next page, page 70, no read petition, my lord. There is a registration certificate, my lord. Registration certificate, my lord. This is the legible copy, my lord. Page 17.
Page 17.
Yes, my lord.
Type copy again.
No, type to no. Nine.
The exhibit, what is this exhibit number?
No, this document was not exhibited, my lord.
ভালোই করবে। You better get the original of this exhibit 1.
Yes, ma'am.
If you can't read, we can't give you anything.
তো legible নয়, তো আসলে plan টা তাদের। Plan টা original টা আসলে
Tribunal also discarded because of
eligibility.
yes, Lord.
No, no, that's something in one appropriate case, we'll have to take it up. You see what is happening. We have flagged that document. Because Mr. Sharma, we are making it very clear. You see, what happens is that we are accustomed to the civil code rules and orders.
Yes, Lord.
In civil code rules and orders, there is a specific provision that an exhibited document, how it is to be dealt with,
Yes,
when it can be returned.
yes, Lord.
Now, here you see, this is the document.
Hmm.
It doesn't even say that it's a true copy or compared copy.
Yes,
And the magistrate has your member has signed it.
Yeah.
Now, can he take a plea that he doesn't know, he can't read? He would have called the original one,
yes, Lord.
and there's no order. You check the order sheet. There's no order sheet of return of the original documents. There's no petition.
Yes,
So he's just like a king in his kingdom. Do whatever he wants to do, and that is the law. And for this, people will be staying in the state of Assam. We will have to remand it. It has to be reconsidered. And for next 10 years, 15 years, these people will remain here. If you don't make a SOP of how these tribunals are to conduct themselves, every time we'll have to remand the matter. Why they can't pass an order that we have returned the original one? Who has taken the original? Now, if tomorrow Mr. Hassan is smart enough, he'll come and say that, I don't know, we have not taken it. Somebody must keep a track of records.
yes, yes.
You see, even we have faith on you. We give you the records, but we have your token signature that you have taken it. My courtmaster knows that the records are with you.
Yes,
So it's not a question of disbelieving you. It's a question of keeping the records straight.
yes.
There's no order. I think the date of
No,
the
no.
signature is the signature does not even have a date.
Date. Mm,
This is not how record should be maintained.
no date was given in.
You have to ask your home department to distribute a bottle of ink to each and every tribunal. Old Dr. Pen. Give it to them. They will fill up ink and then write a date at least.
Document is lack of that. Lord.
Hmm?
Not a single document is there, Lord. The date is there.
But you see, we can only before you can, we can always, we can only express
no
our anguish.
date.
We can't say tell you anything. You are not the.
In exhibit 1 also no date, exhibit 2 also no date.
It's not there. So when it was taken away, that is also not there, no record. It's not a good record keeping. Get it, Mr. Hassan, next week. Because if you can't read, the shortest way is to say that the tribunal cannot read, we cannot read, and therefore yeah, lift and I. And is there any explanation in your writ petition? We have not checked it about this certificate of registration. Have you made any statement in your writ petition?
No, my lord, that not explanation, my lord.
Mr. Viswasila, to give some explanation,
I should have. My lord. Yeah, exactly.
because even
I
at
want
this
to
stage,
Try to contact the client, my lord, whether he is having better copies, anything.
no, not better copy. You must have the original one.
Yes.
Might be.
No better copy. Copy will not do. I'm doing the original one. Okay. As both sides, all sides are represented, as the copy of Exhibit 1, which is appended to the writ petition and available in the records of the tribunal, is not readable. We direct the petitioner to produce the original of Exhibit 1. List when?
After 2 weeks, my lord.
Kindly 2 weeks.
After 2 weeks.
After 2 weeks.
Yes.
Give a fixed date after 2 weeks.
First.
Item 2,
You can advise them. You see, my esteemed sister is very correct. The tribunal, the presiding officer will sign, and the job of fixing the rubber stamp and all these are normally done by the bench assistant.
Yes.
They can write the date in below, because if you don't train them,
Yes.
this is always going to be going to happen.
Yes.
And this is a disturbing scene. You see, at times it is very relevant. We have found those cases here. The date on which the magistrate has signed the document.
Yes.
Is it on the day when the evidence was presented by way of an evidence or an affidavit? Or was it signed on the day when the cross-examination took place?
Yes.
So those things are very relevant
Yes. Sir.
at times. Not in this case, but at times it may become very relevant.
Yes.
So there should be some sort of training to these people how to handle the exhibited documents. Because now you see, the onus is on the state to say where the records went.
Yes, Lord.
In a given case, if the petitioner results and says that I never took the original, and therefore will a doubtful citizen become an Indian citizen just because the documents are lost? It is for the government to think. So where is the original gone?
Yes.
No answer to that. Tell your authorities.
item 2,
It was. when the matter is called, all the respondents are represented. Next para. Take note of the fact that when the matter was previously listed on 6/1/2020 and 14/10/2020, the petitioner remained absent, remained unrepresented when the matter was called. To stop. For answer justice, the matter stands adjourned today. So we make it clear that if the petitioner remains absent on call on the next date of listing, adverse orders would follow. Next list on 11/8/2025. No, make it 13/8/2025. Oh. Nine. Nine. that in the event the counsel holding the brief remains absent on the next date of listing, comma, it would be deemed that the counsel on record is committing a misconduct of not appearing in listed cases, although the names are being shown in the cause list. List on so and so. This time we'll drop proceedings against the counsel for not appearing. Yes, students are there. Yesterday I asked question. Anybody is ready with the answer? No. Yes. Yes, come forward. Don't be afraid. Yes. You have seen the law? Comes closer to the mic.
Yeah, we have written the orders, but we didn't revise it. We have written the orders, but we didn't revise it.
You want to revise it.
We didn't revise it,
You
but
didn't.
we have written it.
You have written. Show it to us. You are in which semester? Third semester. You have done a good job. Okay. Now you can take a back seat. Yes.
Item 3.
Please, Your Worship.
Yes.
My lord, as per last order, my lord, dated 11/6/2025, my lord, I was allowed to, my lord, file my additional affidavit to bring some record so as to establish the linkage of the petitioner with his father and mother, my lord. And probably that is flag marked as like A, my lord, in the file, my lord. The running page starts from page 93, my lord. And the voter list pertaining to the year 2021, my lord, it starts from page 95, my lord. If your lordship, my lord, kindly turn to page 96, my lord. The photographs are there. My lord. I'm very sorry I could not, my lord, produce the certified copies, my lord. I had a very short time, my lord, for which I could not produce the certified copy. But the
You go through it. We'll take it up next week.
and my
The additional documents. You have given a copy to him?
yes, my lord.
Okay.
In fact, my lord, the land document is also that is a certified.
It's okay. Let him go through it.
Yes.
Kindly give one copy.
Next Wednesday, we'll take it up. Next Wednesday, we'll take it up. If he doesn't have copy,
Wednesday, I have a difficulty, my lord. Can it be on next Friday, my lord, if possible?
okay, 25th.
My lord.
The both sides, all sides are represented. The learner counsel for the petitioner submitted, then an additional affidavit has been filed, which is brought on record. Post of Mr. G. Sharma, learned standing counsel for the active matters. Place for some time to go through it in the district court. Stop matter stands adjourned today. This on 25/7/2025.
But
This is for what purpose?
this is for my lord consideration of my interim plan, my lord. What happened in this case, my lord? The documents which he exhibited before the concerned tribunal, my lord, his name was not enlisted together in the same single document, my lord, along with his father, my lord, since he stayed separately in a separate entity. But from the other voter list that I have produced, my lord, I have, my lord, annexed in the additional, my lord, affidavit, my lord. That reflects, my lord, the name of the petitioner along with his mother and
Okay.
brothers. My lord. Deeply, my lord.
Item 4.
Item 4.
Here, my lord, I have received communication from FRRO Kolkata. You know, they say, my lord, deportation order was issued, and now, my lord, there is no action on their part.
No action means
Well, they say, my lord, once deportation order is issued by them, my lord, they have no role to play. And so far as, my lord, Amy is concerned, my lord, I have not received any communication from them.
yes. What is your information?
Your Lordship,
You said that last time they had left.
yes, yes,
They reached Nigeria.
yes, yes, yes.
Then we close the matter.
Yes.
The instructions of
Yes.
your name.
Your Lordship, I'm C. Gogoi appearing on behalf of Mr. D.K. Agarwal.
C. Gogoi.
Yes.
Mr. C. Gogoi, learned counsel, who appears on behalf of Mr. D.K. Agarwal and counsel for the petitioner on record, has referred to the last order dated 26/6/2025, wherein the learned counsel holding the brief had submitted that as per information received by him, the petitioner has already reached his home. Next para. Mr. M.R. Adhikari, learned CGC, has submitted that as per instructions received by him from the FRRO, Kolkata, once a deportation order is issued, they have no role to play. Full stop. However, he has submitted that he is yet to receive appropriate instructions from the Minister of External Affairs, Government of India. Next para. As the learned counsel for the petitioner has reiterated that as per instructions received by them, the petitioner has already reached his home. The court is of the considered opinion that nothing further survives in this writ petition. Stop. Accordingly, the accordingly, the matter stands closed. Next, as the matter is being closed without appropriate instructions from the Minister of External Affairs, Government of India, we grant liberty to the petitioner to move the court again if in the event the deportation has not taken place.
Well,
Right.
all right.
Disposed of.
Item 5.
No, you don't have to write there, but you show it at this point. This will be disposed of. Item 5.
Back to lordships, my lord. On the last occasion, your lordship was pleased to direct and call for the record LCR, my lord. And now I just want to take your lordship to Annexure D, page 30, which is in order of the application, Nogam. And this order was passed, my lord, without hearing me ex parte order, my lord. I honestly confess, my lord, and honestly state before lordships that it is my mistake that the order was passed on 2018, but now today, this is 2025, that I confess, my lord, that is was my mistake. But at the same time, my lord, I just want to draw your lordship's kind attention to Annexure E, page 31A. Annexure E, page 31A.
Yes.
My lord, I belong to Moria community, the indigenous Assamese Muslim came during the reign of Ahom rule, 1637, my lord. So, my lord, I may be given an opportunity to hear me, my lord, and after that I have got no objection.
Mr. Payang, you have come. Yes. What do you say, Mr. Payang?
My lord, first of all, my lord, your lordship may kindly see the order sheet is annexed here with.
Pardon me?
Order sheet is annexed here with in the writ petition.
No, this, it was not there. You can see it from here. There was, the order of written statement was not there. That's why we call for this.
My friend is question asking me to look the orders it, orders.
We have seen that.
But a WS was filed. Yes, that is there on 16/12/2014. That record is there. Thereafter, my lord, the proceeding has taken time. Numbers of times, in fact, it is uncountable to file evidence. That is not fine. The finding no alternative, my lord. In fact, your lordship will find from 2014, 16/12/2014, the WS was filed. Thereafter, he seek time to file evidence. My lord, till 2018, my lord. On 2017-2018, OP is absent without steps and hard AGP. Next date is fixed on 31/10/2018 for order and opinion. So only on 2017-2018, after 14, 15, 16, 17, 17, after 4 years, the tribunal has not given enough time to the proceeding to file evidence. After 4 years, my lord, it was heard expert. And AGP was heard in absence of the petition proceeding. And on 31/10/2018, opinion is passed. So there is no infirmity at all. In fact, my lord, the Foreigners Tribunal Order 1964 has provided only, my lord, 60 days time. But tribunal has given, my lord, 4 years time. No payment. 64. No, 1964. Page 150. 159. That is. Five,
60 days, 14,
60
yes.
days, yes. 14. The Foreigners Tribunal shall dispose of the case within period of 60 days of the receipt of the reference from the competent authority. That is one aspect, my lord. Another aspect, my lord, it is not the case that the proceeding was not aware about the pending of the case. He was well aware, participated in the proceeding. My lord, the opinion was passed in 2018. Now they are challenging it 2025. Lapses on the part, not only not, in fact, I'm not saying about delay, my lord, lapses on the part of the proceeding. That has to be seen. A writ petition challenging the opinion of 2018 after, my lord, 7 years. It's not permissible. Because the law provides within, my lord, in fact, a review, there is a review provision of expertise. That is also within 38 days, my lord. 3C, my lord.
Yes.
Proceeding for setting aside expertise order. There is a provision for review. Where the foreigners tribunal has passed an ex parte order for non-appearance of the proceeding, he or she sufficient cause for not appearing before the foreigners tribunal, it may on the application of the proceeding, if filed within 30 days of the said order, set aside ex parte order. There is a provision for review, and it should be filed within 30 days. So the delay in lapses on the part of the petitioner, though he is trying to explain in para 6 of the writ petition, para 6 or 7 probably. Your lordship may examine whether this is tenable on the para 6 of the page 5 in the writ petition matter. Due to passing of the opinion, the petitioner is in mental stress, and the petitioner's one close relative also contacted one advocate in Guwahati High Court and requested the concerned advocate to file a writ against the order of the learned foreigners tribunal 6th Nagaon before the Guwahati High Court. But since then, the petitioner did not make any communication to the learned advocate, which the petitioner himself admitted his fault for not filing this said writ. So it is not a proper explanation. Lapses is clear on the part of the petitioner. So my humble submission is, my lord, that this petition is to be dismissed on the ground of delay in lapses. First. Secondly, my lord, he intentionally did not file evidence, and the opinion passed by the tribunal is not bad in law. There is no error apparent, or there is not it is not the case that the petitioner was not given chance. He was given enough chance. Under certiorari jurisdiction, your lordship may, my lord, please to, my lord, not entertain the present writ petition.
My lord, I've got highly profound respect for the argument put forwarded by my learned friend, my lord. That is true, my lord. But my lord, as the law stipulates that it should be decided within 60 days' time, my lord. But the law is in paper. Actually, my lord, all the foreigners cases that is going on in Assam, the legal statistics say that you will need 300 years to dispose all the matters, my lord. These legal statistics, my lord. And I honestly confess, my lord, that is my mistake, my lord. And why I have filed this writ petition, my lord, but that is a settled principles of law that there is no any limitation for filing a writ petition, my lord. Only I can say, my lord, as Martin Luther King Jr. once addressed to the American public, that injustice anywhere in the world is a threat to justice everywhere, my lord. I leave it to your lordships, my lord. I have knocked at the door of your lordship's majesty to grant me justice, my lord.
Okay, we'll consider and pass orders.
But I'd like to just hand over two judgments of decisions. This is, my
My
lord,
lord, I can also be permitted to file the Supreme Court judgment, my lord, which I
You'll have to do it within some time.
my lord. Can I get a fixed date, my lord? Can I get a fixed date, my lord?
No, we are disposing out of the matter today.
My
So before lunchtime, you give it.
highly obliged, my lord. Highly obliged.
But give the citation to the other side also.
My lord.
Yes, item 6.
Item 6 and 7, my lord, they were, my lord, in the detention camp, my lord, they were supposed to file an affidavit, my lord. In 7, it has been filed today, my lord. I got it on 11 p.m., my lord. I got it in a copy, my lord. 6, it has not been filed, my lord. 6, it has not been filed. In item of 7, it is filed, my lord.
7, we have filed an affidavit, my lord. We'll rely on the same affidavit in 6 also.
Okay.
Because it's
They have not filed, my lord.
stand is same stand, my lord.
But it has been filed today.
Yes, we have filed today only, my lord. Sorry for.
We have filed today.
Yes, my lord.
We'll take it up next week.
Yes.
Both all sides are represented. Mr. J. Pang, standing counsel for the FT matters, has submitted that an affidavit in opposition has been filed
In item number
in
7.
In WPC
3101.
3101/2025, on which he intends to rely in connection with this writ petition. Full stop. Let a copy of this, let the said affidavit filed today be tagged with the record. Full stop. Copy thereof be provided to Mr. M. Datar and counsel for the petitioner.
Copy isn't provided.
Copy isn't provided. Okay, then notify. List on next Wednesday, 23/7/2025. And in this next writ petition, list on sent 23/7/2025. Both sides are represented.
Well, they have made a statement that they'll be relying upon, my lord, the same affidavit in, my lord, item number, that is petition number 314, my lord.
No. 3101.
No, 310 you have filed, but 3131, what? 314, no, 314. 3099. 3099.
Is it listed today?
Item 6 and
Yeah,
7.
6 and 7.
In 7 they have filed, 6, my lord.
So that's what we have said. In this next case, we are just saying that list on so and so.
7.
Item 8.
Item 8, my lord, the petitioner, my lord, was found, my lord, in a street, my lord. He was taken to home, my lord. Then there was a, my lord, we said that we'll produce him, my lord. In fact, he was produced before the, my lord, SP border on 10th of July, but the SP was not present. My lord, he is unwell, my lord, and thereafter he could not be produced because, my lord, he is perhaps unwell, my lord. He is undergoing treatment, my lord. I've got some, my lord, documents, of course, my lord, been sent by, my lord, hard copies I'm yet to receive, my lord.
But in this case, if he is already released and he has not been taken into custody, then this writ petition can be closed.
Yes, otherwise he's in, my lord, he's not in custody. That's true.
If he's not in custody, question of deportation will also never come. We close it with liberty to you to move the court again if you are aggrieved.
My lord.
Mr. M. Datar and counsel for the petitioner has submitted that the petitioner, namely Bakar Ali, has been recovered from Bijni.
No, not Bakar. Bakar is the father, my lord. Samsul Ali, my lord. Yes.
Achha.
Yes. Son filing.
The father of the petitioner, namely, what is the name? Samsul Ali. Just say it differently. The petitioner in this case is Bakar Ali, and as per instructions received from the petitioner, the father of the petitioner, namely, Samsul Ali, has been recovered from Bijni in an unconscious state and has been brought home. Stop. It is submitted that the father of the petitioner was produced before the office of the Superintendent of Police, border, Chirang, but as the said authority was not available, his presence could not be recorded. Stop. However, thereafter, the father of the petitioner is not keeping good health, for which he could not be produced before the said authority. And he's currently under treatment. Next para. heard the submissions made by the Learned Standing Counsel for the FT matters. Next, considering that the father of the petitioner has been recovered, and not taken into custody, the apprehension of his deportation would also not survive. Next para. Accordingly, by granting leave to the petitioner to approach the court again, if is threatened with if is still aggrieved by any action of the state, is the father of the petitioner has been recovered and is at home, the purpose of this, there's no purpose would be served to keep this matter alive. So accordingly, with liberty as indicated above, this petition stands closed.
Obliged.
Item 9.
Lots of matter other than the ordering, so nothing was annexed thereof. I'm seeking 2 weeks time to bring the written statement, other relaxed documents.
You not get it. Please repeat again.
2 weeks.
2 weeks time.
2
You want an adjournment. Both sides are represented on the prayer made by Learned Counsel for the petitioner. List after 2 weeks.
Diplomat.
Yes, item 11.
Imping opinion dated 30/5/2025.
Which page?
112.
Okay. But Mr. Ayuddin, Learned Counsel for the petitioner. All the respondents are there. Page 112, opinion dated 30/5/2025. Asked by so and so in case number so and so, police reference number so and so. They were declaring the petitioner to be a foreigner post 25 in 1971 stream. Notice extra copies within 2 days. Records to be called for. Prayer for bail is opposed by the Learned Standing Counsel for the FT matters. Bail of rupees 5,000. 10 days time to take bail of 5,000 to the satisfaction of
SP Border Nagaon.
SP Border Nagaon.
I am also.
Notice 4 weeks.
Please, Your Lordship. Common ex parte complaint order, Your Lordship, only page
Page.
68, Your Lordship. Operative portion, page 78. Page 68. Operative portion.
This is your case number,
My case number is number 2, Your Lordship.
serial number 2,
Serial number 2,
Hafiza Khatun.
Hafiza Khatun. Page operative 78, para 7, Your Lordship. 6 and 7. May I read, Your Lordship? Moreover, as required under Section 9 of the Foreigners Act 1946, the burden to prove that she is a citizen of India and not a foreigner lies in the proceedings, and the state has no role to play because it cannot prove the negative fact. The present proceedings have therefore absolutely failed to discharge their mandatory burden to prove that they are the Indian citizen and not the foreigners. The allegations as made by the state, that is referral authority, to the effect that the accused are the foreigners who have had illegally entered into.
We annex the service report.
Your Lordship.
Which page?
Please kindly see page number 67, Your Lordship.
67.
Barnacular, Your Lordship. 67 Barnacular, Your Lordship. প্রতি মহামান্য বিদেহী ন্যায়াধিকরণ মহোদয়, সম্মান সহকাৰে জনাও যে উক্ত বিদেহী ন্যায়াধিকৰণৰ জাননীত উল্লেখিত মহিলাগৰাকীক আমি বিচাৰি যাওঁ আৰু উক্ত স্থানত মহিলাগৰাকীক বিচাৰি পোৱা নগ'ল। সেয়েহে গাঁওবুঢ়াৰ নটিচ বৰ্ডত লগাই লটকাই জাৰি কৰা হ'ল আৰু মহামান্য আদালতলৈ নটিচ কপিটো পুনৰ বিচাৰৰ বাবে প্ৰেৰণ কৰা হ'ল। Here, Your Lordship, the গাঁওবুঢ়া's notice board, the 2 নং নেগেৰী বিল মিছিং গাঁও, Your Lordship.
Mr. Sharma, this is not 35G. We'll have to, will any purpose serve to call for the records and then
Yes, Lord.
decide the matter? If it is
Lord.
not 35G, then we set it aside.
Yes, Lordship.
My Lord, I am the inhabitant of.
But you'll have to satisfy the court, why 2018 opinion we should interfere now after a period of 7 years.
My Lord, notice, the address of the notice, address of the notice person is Negaribil Muslim Gaon, Your Lordship, whereas the petitioner is inhabitant of Merapani Muslim Gaon, Your Lordship. The Gavura of my village is Zakaria Ali one, Zakaria Ali. And the notice served on the notice board, the Gavura of that village is Kanta Bayang, Your Lordship. Kindly see page 67.
Page 57.
67, Your Lordship. Jaikanta Payang, Gavura, Dunam Negari Bill, missing Gao, Your Lordship. There is another village, Your Lordship. I am not independent of that village. Your Lordship.
Please come to the service report again. Please read that again.
Your Lordship, page 67.
Yes.
প্রতি মহামান্য বিদেহী ন্যায়াধিকরণ মহোদয়, সম্মান সহকাৰে জনাও যে উক্ত বিদেহী ন্যায়াধিকৰণৰ জাননীত উল্লেখিত মহিলাগৰাকীক আমি বিচাৰি যাওঁ আৰু উক্ত স্থানৰ মহিলাগৰাকীক বিচাৰি পোৱা নগ'ল। সেয়েহে গাঁওবুঢ়াৰ নটিচ বৰ্ডত লগাই লটকাই জাৰি কৰা হ'ল। তাতে আৰু মহামান্য আদালতলৈ নটিচ কপিটো পুনৰ বিচাৰৰ বাবে প্ৰেৰণ কৰা হ'ল। এতিয়া আপোনাৰ বিশ্বাসী কনষ্টেবল পূৰ্ণানন্দ সোণোৱাল আৰু 2 নম্বৰ কাঞ্চন ফুকন, মেৰাপানী আৰক্ষী থানা।
Yes. So which Gambura?
Is Your Lordship, can you see? Sri Joykanto Payang, above the.
Where you are reading? Page?
Page 67, Your Lordship.
57.
67.
Above the report, Lord.
Above the report. Okay,
Yes, Lord.
okay.
Set. Sri Joykanto Payang, Gavura, 2 নং Negari Bill, missing Gao.
Yes.
I am inhabitant of Merapani Muslim Gao, Your Lordship. And our Gavura's name is Zakaria Ali. And this another Gavura, Your Lordship. That is why I could not trust out.
Yes, Mr. Pang,
Lordship.
what should we do?
Lordship.
We have a very good concept. We have a theory called back to school.
Lordship. No, this was not properly served if Lordship. Oh.
No, but the Jari Kharak does not know where to serve.
Yes, Lord.
The presiding officer of the tribunal does not know how to accept a.
Yes, Lord.
Your Lordship, in the notice itself, address is very well.
If this is not an alarm bell for the state, nothing would be. This performance of this members of the tribunals will have to be. Now we will be interfering with the opinion of 2018.
Lordship.
Two 26 of the Constitution of India, the petitioner, namely so and so, has assailed the ex parte opinion
Do you want
the common opinion dated
if you want
common ex parte opinion dated 21/12/2018 passed by the learned member, Foreigners Tribunal, Jorat, in respect of case number capital FTG within bracket capital D bracket close 497/2010, page 68, serial number 2. Simple. Highlighting the casual manner in which the Foreigners Tribunal had proceeded with the matter, the learned counsel for the petitioner has referred to Annexure 18 capital A of the writ petition, which is a notice issued to the petitioner for appearance before the learned tribunal. As per the said notice, the same is addressed to Muhammad MUSSTT, Hafiza HAFIZA, Khatun KHATOON, wife of Muhammad MD, Suraj SURUJ Ali, comma, village, VILL, village dash Neghribil, NEGHERIBILL, Muslim, next is Gaon, comma, PS, Merapani, MERAPANI, comma, district Golaghat,
Missing down,
DIST. Pardon me,
missing down, not missing down.
MUSLIM.
Muslim Gaon. Notice was right.
Huh?
Notice was issued in Muslim Gaon, Neghribil Muslim Gaon, but it was served on
It's okay.
missing Gaon. Neghribil missing Gaon, Gaopuras notice board.
Negligible missing down. Notice was served on negligible missing down. Now, petitioner is claiming that he was resident of Merapani Muslim Gaon.
Issue notice returnable on so and so. Give a date after 4 weeks. Extra copies within 2 days. Call for the relevant records from the concerned tribunal. The prayer for bail is opposed by the understanding counsel for the FT matters on the ground that the notice was duly served in accordance with law. Next para, in view of the projection made in this writ petition, comma, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Forest Border,
Jorhat, Golaghat.
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 Okay. List also.
18-8. 20/8. 20/8.
We'll take a short break and come.
20/8. Supplementary item 31 for motion.
Yes, which is the order?
Page 64, Malad.
25/11/20.
Okay. Take the draft from. Mr. A.K. Azad, Learned Counsel for the petitioner. All the respondents are there. While filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 25/11/2024, page 64, asked by so and so, in case number so and so, reference case number so and so, thereby declaring the petitioner to be a foreigner of post 25/3/1971 stream. Notice extra copies, notice returnable in 4 weeks, extra copies within 2 days. Call for the records. Next para, the prayer for bail is opposed by the learned standing counsel for the FT matters. Stop, however, considering the projection made in this writ petition, 10 days time to take bail of rupees 5,000 to the satisfaction of
SP
Superintendent of Police Border.
Borpeta.
Borpeta. Okay. List after 4 weeks.
Item 32.
Please, Your Lordship. Lordship, opinion is at case number. Lordship. Opinion is at case number 110, Your Lordship. 110, Your Lordship.
110.
Next, the 18 series, Your Lordship.
824. Okay.
Your Lordship sees in detention, Your Lordship. Detention time. So IA has also been preferred, Your Lordship.
In detention. Lord.
Detention, Your Lordship.
Is he in detention?
Lordship. In Your Lordship, Holding Center 7 Assam Police Battalion, District Kokrajhar, Your Lordship.
Okay. Was taken into custody when?
23rd, Your Lordship.
On?
But it was Your Lordship, what happened? It was earlier Gwalpara, she was detained.
No, the petitioner was was taken into custody on which date?
23rd May.
25th May.
23rd, Your Lordship.
23rd.
3, Your Lordship.
This petition will be like the last order. Ms. G. Baral and counsel for the petitioner. The opinion is at page 110, dated 21/8/2024. Passed by so and so in case number FTG so and so, police inquiry number so and so. They were declaring the petitioner to be a foreigner of post 25/3/1971 stream. Receipt name, extra copies. The next paragraph would be the learned counsel for the petitioner has submitted that the petitioner, namely Rubeda Begum alias Rabeda Begum, was taken into custody on 23/5/2025, for which a separate interlocutory application has been filed for bail. Text file accordingly. Let the relevant records be requisitioned from the concerned tribunal through usual process as well as through email at the following email address of the learned tribunal. That the secretary will give it to you, right? Email address. Next list on give a date after 4 weeks. 20 August 2/08/2025. And in this IA, you say, heard so and so. You should notice on this application for bail, which is made returnable on 28/2025. Most of the prayer for bail shall be considered on receipt of the tribunal's records, for which order has been passed in the connected rate petition. Next paragraph. In the meanwhile, the petitioner Rubeda Begum alias Rabeda Begum, who has been taken into custody on 23/5/2025, pursuant to opinion dated 21/8/2024, passed by the learned member, Foreigners Tribunal Jorhat in case number so and so, shall not be deported out of the country without order of the court. Next para, the petitioner shall, the applicant shall, not the applicant, the family members of the applicant shall produce a certified copy of the order before the Superintendent of Police within bracket border, bracket close Golaghat, would inform the holding center at 7th Assam Police Battalion, Charaikula, District Kokrajhar, where the petitioner is currently lodged. Next para. We also request the learned standing counsel for the FT matters to communicate a downloaded copy of this order to the Home and Political within bracket B department. To bring the notice, to bring the order to the notice of the said authorities. Next para, list on 28/2025.
Item 33.
This is a contested case, Lordship. With petitioner is a lady, Lordship, and opinion is at page 61, annexure 14, Lordship. Opinion dated 17/6.
Page number
61.
61.
Dated 17/6/2025. Copy exhibited 14 documents, Lordship, and adduced the evidence of her birth.
But Mrs. Chaudhary, learned counsel for the petitioner. All the respondents are there. I filed this petition under Article 226 of the Constitution of India. Or the petitioner has assailed the opinion dated page 61, dated 17/6/2025, passed by so and so in case number so and so. And arising out of IMDT reference case number so and so. I put a tick mark everywhere, page 61. By which the petitioner was declared to be a foreigner post 25/3/1971 stream. Notice returnable in 4 weeks, extra copies within 2 days. Let the relevant records be requisitioned from the concerned tribunal. Express the prayer for bail is opposed by the learned standing counsel of the FT matters. Considering the projection made in this writ petition, 10 days time to take bail out of this 5,000 to the satisfaction of Superintendent of Police Border, Bongaigaon. List out of works on receipt of tribunal's records.
Obliged.
Item 13 for admission.
water cosmos দুটা কেস আছে দুটা কেসত একেলগে water cosmos
Yes.
Yes, madam. Can we come on page number 40, your lordship? This is the income order, your lordship.
40.
Yes, madam. In this case, your lordship, two cases are amalgamated and pass order together, your lordship.
Yes.
The two cases are between, one case is my brother and me, your lordship.
Yes.
And only reference issued against me and my brother, your lordship, but declared foreigner, all the family members. Over the whole family members now.
Okay. You've seen the report?
No,
You check it. Into the report. We'll take it up after some time. Let him go through the reports.
Lordship may fix it day after tomorrow or tomorrow. Day after tomorrow or tomorrow. Any day.
We have, it's not a very good time. Yeah. You only have to check it if there's no reference against the other family members.
Then
Against 6 people, at least it should not continue.
Yes,
For the rest of the matters, we can continue with the
yes.
writ petition.
Yes, Lordship.
Just check that, only that part. We'll take it up at 2 o'clock.
Yes.
Go through it at your time.
Okay.
Item 14.
Yes. Your affidavit has been filed.
Yeah, Malad, we have filed the affidavit.
Okay.
On 18/6/25.
Okay. Where is the order? Which page is the order of the learned single judge?
Yes. It starts from
83, 84 is stuck.
85, it starts from.
Your petition was dismissed. Mr. Nath, what do you intend to say by this paragraph 2 and 3?
Of the affidavit, present affidavit. my lord.
Yes.
My lord, what we have placed, for a moment, kindly take up the affidavit filed in the writ petition at page number 47. It is available there, my lord.
So
This is the affidavit filed by the Secretary of the Department.
just tell us in short so that
Lord,
after we read it, they will understand.
Our case is that in that particular ICDS project, there are total 400 posts of Anganwadi workers. As per the scheme, the 25% post has to be filled up from upgrading the Anganwadi helpers to the post of Anganwadi worker. 75% is to be filled up directly. The scheme which we are following, it provides that the Anganwadi helpers who has completed 10 years of service and who are within the same revenue village. The mechanism is, the Anganwadi worker and helper has to be from the same the jurisdictional area of the Anganwadi center. While upgrading the Anganwadi helper to the Anganwadi worker, we have extended that scope little bit. And we have said in the guideline, it is there, I'll take your lordship to that the Anganwadi helper within the same revenue village. In a revenue village, there may be 2, 3, 4 Anganwadi centers. So we have widened the scope of upgradation of the Anganwadi helpers within those 3 or 4 Anganwadi helpers. If some Anganwadi worker post because of some reason fell vacant, because at the initial entry level, when we started the Anganwadi centers, there is no scope for filling up the 25% post. At the initial, we have to go directly. Subsequently, whenever vacancy comes, up to 25%, we have to fill it up in that manner, giving the opportunity to the in-service Anganwadi helpers. So in this particular Anganwadi ICDS project, out of 400, at that point of time, only 21 number of Anganwadi helpers were upgraded as Anganwadi workers. So still 79 posts of Anganwadi workers are to be filled up to maintain the 25% the quota. So what we have done, we have issued the advertisement to fill up the Anganwadi post of workers by upgrading the Anganwadi helpers in that respective Anganwadi centers. The petitioner have made a challenge that out of all 20 posts, only 25% you should have kept for promotion and rest should have been filled up by direct. So in our affidavit, we have said that the position is like this, that out of 400, 25% it is 100. So we can go up to.
So now you are giving the statistics of the cluster wise, the revenue village wise.
Revenue, yes, Paula. Upgradation opportunity is given to the helpers, revenue village wise.
Revenue village.
In fact, what has happened, Paula? In the affidavit, we have also indicated after issuance of the advertisement also, we have not found the eligible helpers for upgradation. In that case, again, we have to go for direct recruitment. It is not a case that Anganwadi helper, if we issue the
21 or so.
21 is already filled up. In respect of others, suppose an advertisement issued and the Anganwadi helpers, 2 or 3 Anganwadi helpers available, they participate in the selection process, they may not be eligible because 10 years and other criteria are there. In that case, again, we have to fill that post by direct recruitment. So in this particular case, on last occasion, Lordship has heard the matter and the order was passed on 23rd of May 25. That order, for a moment, if Lordship finally takes up. Yes, and in fact the observation Lordship has made in that order, they kindly take up paragraph 2 of my affidavit. I have in fact quoted in the page number 95. No?
Just a moment. Yes.
Page number 95, para 2. The deponent begs to state that the Honorable Court, after hearing the parties in the instant writ appeal by an order dated 23/5/25, has observed that the state respondents are required to file an additional affidavit detailing that out of 400 posts of Anganwadi workers in Gauripur ICDS project, how many posts are occupied by direct recruitees and how many persons have been promoted to the post of Anganwadi workers from the post of Anganwadi helper, taking note of the submissions made on behalf of the respondents that 75% quota of the Anganwadi workers, which is required to be filled up through direct recruitment, is already saturated. In compliance with the aforesaid order dated 23/5/2025 passed by the Honorable Court, this additional affidavit is being filed, bringing on record the required information. Next paragraph. That the deponent begs to state that there are altogether 400 Anganwadi workers posts under Gauripur ICDS project, and out of 400 posts, at present 355 numbers of Anganwadi workers are in position and 445 Anganwadi workers posts are vacant as on today. Out of the aforesaid 355 incumbents, 20 numbers of posts have been filled up by way of upgradation, and other 335 posts are recruited directly. As per the stipulated norms of promotion, 25% out of total 400 posts, that is 100 posts of Anganwadi workers, are to be filled up by way of promotion from the Anganwadi helper. Presently, 20 numbers of posts have been occupied by promotees, and altogether 335 posts of Anganwadi workers have been occupied by direct recruitees. Further, in respect of 45 existing vacancies, the Anganwadi workers, the following steps have been taken. Already sent for approval to the Directorate Office is 70. Means here already the process is almost over. If we get the approval, we can issue the appointment order, upgradation order. Second category is already sent for upgradation for approval. Here the approval has been sought for the director. If director approves us, we will initiate the process for upgradation by issuing advertisement and all. New advertisement is for 10 posts. After initiation of upgradation process, no eligible helpers are found. In respect of 10, we have taken up the process, but no eligible helpers we found. Therefore, we have to issue new advertisement for these 10 posts. Advertisement for upgradation is already one, and new vacancy has in the meantime has arose is 10. So these are the 45 vacancies as on today. Lord, one more aspect, Lordship may kindly.
No, it's okay. We have just heard you on this affidavit. Because let Mr. Ahmed begin, because we have not heard him.
Yeah.
Then we'll come back to you.
Yes. Lordship.
Yes, Mr. Ahmed.
Yes. Lordship, page 44.
We just wanted to understand your affidavit.
Lordship, page 44, Lordship. This is the notification by which the 25% post of the Anganwadi workers to be filled up from the Anganwadi helpers was introduced in 2006, Lordship. Page 44.
Yes.
And Lordship, may I give this copy was legible, Lordship?
Yes.
Otherwise, I have the legible copy. Lordship, it is issued by the Ministry of Women and Child Development to the secretaries in charge of ICDS in all states and UTs, subject to reservation of 25% of posts of Anganwadi workers from Anganwadi helpers. Sir, Madam, as you are aware, the Anganwadi worker and Anganwadi helper are the most visible grassroots functionaries at the village level under the ICDS scheme. You are also aware that with a modest beginning of 33 blocks in 1975-76, the scheme has expanded gradually, and presently it covers 6,116 blocks across the country. Recent years have witnessed not only a considerable increase in the number of ICDS projects / Anganwadi centers, but also significant efforts aimed at ensuring quality in the delivery of service and community participation. Needless to mention, the responsibilities of these grassroots workers have also increased over the years. While we have been concerned about providing some opportunities of further growth to Anganwadi workers, it was never thought of the Anganwadi helpers in the same vein. It has therefore been felt that similar opportunities, as in the case of Anganwadi workers, should also be provided to the Anganwadi helpers to motivate them to discharge their functions more efficiently. Accordingly, this is important, Lordship. A decision has been taken to reserve 25% post of Anganwadi workers to be filled up from Anganwadi helpers who have put in minimum 10 years of satisfactory service and also possess the requisite qualifications, that is age, education, etc., as laid down by the concerned state government of the Union Territory Administration for selection of Anganwadi workers. This will apply in respect of all existing vacancies of Anganwadi workers and new vacancies arising out in future in the newly sanctioned Anganwadi centers. The guidelines issued by the ministry in the past that Anganwadi workers, helpers should be from the same village would, however, have to be adhered to while giving effect to this new policy initiative. The state union territories are therefore requested to give suitable instruction to all authorities concerned with the implementation of ICDS scheme in their state union territories to strictly follow the above guidelines while selecting the Anganwadi workers. Lordship, this was introduced in 2006, and my case is that in the year 2022, there was a vacancy arises 20 numbers due to superannuation of the incumbents, and the respondent authorities out of 20, 17 number posts were advertised for upgradation or promotion. Because this notification, this is specifically stated existing vacancies. There is existing 20 vacancies. They ought to have, as per this notification, to advertise only 25%, that is 5 posts, but they exceeded 70 number of posts. And Lordship, their Lordship projected their case that it should be also single judge also held that on their submission, the post in the ICDS Gauripur ICDS project, it should be counted with project wise. They projected that there are 400 Anganwadi centers. So 75% and 25%, there should be 300 and 100. And 300 should be direct recruited and 100 should be by promotion. But in the latest, they have submitted the list. I have also marked. They also exceeded the direct recruitment also. They are allowed to only 300 posts by the direct recruitment. There they have stated that 335 by direct recruitment. And they are now going to fill up by way of promotion on record. And Lordship, the more important thing is that I have also said in 2021, in 2020, yes, it's 2021, there is a 9 appointment, direct recruitment, Lordship. There is 9 direct recruitment, 9 posts. It should be, there is a 9 vacancy. They recruited 9 posts directly. And in 2000,
you're reading from where?
Lordship, the list they have submitted. I Lordship, gone through the list, I have calculated in 2021, there is a nine posts they are filled up by direct recruitment. The vacancy arises 9, they appointed 9 directly. And in 2022, there are 5 posts, they gone, all the posts upgraded. They never followed this lordship notification in direct 2575 manner lordship. And they choose the pick and choose policy lordship. The lordship, I have mentioned lordship 2021. This is page 98, serial number 2829, page 99, serial number 45, page number 100, serial number 101, page number 102, serial number 152, 153, and 159. Page number 103, serial number 205, page number 108, 352. In 2021. Because they also taken a plea that the direct recruitment posts are already saturated. The 300 posts are already saturated. Then why lordship they are going to fill up again by direct recruitment? Even last occasion, I have also give one document, lordship perhaps it is on the record. This is lordship, this is advertisement for 2023. There occurs only one single post vacancy and they advertise it for direct recruitment. Otherwise, in 2022, I have lordship, the advertisement which I have challenged, it was for 2022. In 22, they have said that the direct recruitment posts are already saturated. And in 2022, 23, again they have gone for direct recruitment. And even in the list also, there are 3 posts I have seen, they are directly recruited in 2023. Because they never followed lordship, the 75-25, which is a guideline lordship.
Okay. Resume 2.
No, please, lordship. I am sorry, this time I am mentioning that I have some problem, my lord. I have an item number 20, my lord. I pay for a short accommodation on next week. My lord, my health condition is not good. From yesterday, I am suffering from viral fever. Now I'm not feeling well, my lord. Next week, my lord, any date, item 20. My lord.
It goes after for 2 weeks, but this next week we have some difficulties.
My lord.
20, okay. List after 2 weeks as paid for and cost for the petitioner. But say both sides are represented.
Highly obliged, my lord. Okay, I'm deeply obliged.
Lordship, kindly lordship, take the additional affidavit, lordship.
Yes.
Lordship, page 98. Lordship, the name of Anganwadi workers, date of engagement, so and so. Here, lordship, Serial number 2, Shohida Khatun, her date of engagement 24/19/98. Serial number 4, Drupadi Nath, date of engagement 14/7/1988. So what I'm trying to say, this Anganwadi project was established in the year 1988. And till 2006, there are 111 Anganwadi workers appointed directly, Lordship. Till 2006, prior to introduce the 25% reservation for formation, 111 posts were directly recruited. Then, Lordship, how, Lordship, it can be calculated as a whole while we are taking the ICDS project wise? Because there are 400 posts. Prior to 2006, 111 posts are already directly filled up. How this 111 shall take into account while calculating the 25% and 75%? And these 400 posts are not created by one day. It is by stage and stage wise created. How it can be, Lordship, calculated? Then project wise it will be 100 and 300 will be direct. It cannot be otherwise. The notification of 2006, it is unequivocal term. There should be an existing vacancies.
Just tell me, I'm just having a query.
Yes, yes.
Let us say in 1965, when this bar was there were 50 members. In time, people joined bar, Guwahati High Court Bar Association. Now we have about 5,000.
Yes.
Now, the total bar membership, how will you explain to others?
So I could not get the point. Actually, what I
You are trying to say that the earlier the ICDS people have they were 100 direct recruited.
Yes, yes, yes.
Now how they are calculating at 400?
Yes, yes.
If that means the cadre strength of the Anganwadi workers is now 400.
Yeah, total.
That's why I'm asking a question.
Yes, yes.
My question, I always ask in a different way.
Yes.
If that's why I'm asking, if the
Yes.
bar membership was in 1965 was 50,
Yes.
now we have 5,000.
Yes. Yes.
How will you describe the membership of the bar?
No, Lordship, I am saying what? Because the 25% reservation is introduced in the year 2006. From then, when it was implemented, from then it should be calculated as a 25-75%. Prior to that,
What happens to earlier people, according to you?
no, Lordship, according to me, as per guideline, there should be the 25%, 75%.
25% off?
Anganwadi helpers who will be promoted from amongst the Anganwadi helpers.
No, this
The existing-
25% would be from strength of total strength or from the strength from the after this
Yes.
after the scheme came.
Yes.
Yes means
but
tell
the
us.
scheme itself says.
No,
this
no.
would be
Just
calculated.
give us a
Yes.
simple example.
Yes.
In let us say in next year,
Yes.
there were 10 Anganwadi workers.
Yes.
After this scheme, there is 20.
Yes.
So according to you, this 25% will be calculated on 10 or 20.
Obviously, it will be from 10. Next, from the date of implementation, those were vacant, false vacant. Those posts were false vacant.
Oh, then we can only suggest that
No,
in the next elections, you can
No, Lordship. That is not the notification itself says, Lordship. Kindly,
prospective.
Lordship, in that notification, that is why, Lordship, it is not my Lordship interpretation. This will apply in respect of all existing vacancies of Anganwadi workers and new vacancies arising out in future in the newly sanctioned Anganwadi centers. If the new Anganwadi center is created, 5 Anganwadi center is suppose created.
You are reading where?
Lordship, in page 44. Page 44, in the middle. in the middle paragraph, Lordship. This will, Lordship, this will apply in respect of all existing vacancies of Anganwadi workers and new vacancies arising out in future.
Definitely.
Yes.
Because otherwise what would happen?
Yes.
Let us say that there are 10 persons in the Anganwadi helper or Anganwadi worker. If the vacancy 25% arises, including them, then out of these 10 people, 25% has to go to give effect to reservation.
Yes.
Therefore, it is said that it will apply on the new vacancies.
Yes.
But the total strength, the total cadre strength will not change.
Yes, 100. Yes,
If it is 400, it is 400.
Yes.
So 25% will apply.
Yes. If I agree also that point, they have, Lordship, directly recruited already 335 out of 400. And they already crossed the 75% norms. The affidavit, Lordship, itself, paragraph number 3, out of aforesaid 355 incumbents, 20 number of posts has been filled up by way of upgradation, and other 335 posts are recruited directly.
Yes.
Yes, Lordship. Lordship, in the affidavit, the order of paragraph number 2, Lordship, in the affidavit. Here the last order reflected, Lordship. Page 95, affidavit, Lordship.
Yes.
Lordship, the Honorable Court, after hearing the parties in the instant writ appeal by an order dated 23/5, that I am referring 25 order, Lordship, observed that the state respondents are required to file an additional affidavit detailing out 400 posts of Anganwadi worker in Gauripur ICDS project, how many posts are occupied by the direct recruitees and how many persons have been promoted to the post of Anganwadi worker from the post of Anganwadi helper, taking note of the submission made on behalf of the respondent that 75% quota of Anganwadi workers who is required to be filled up through direct recruitments is already saturated. They have said that while the advertisement was issued in 2022, the post of 75% who are required to be filled up through direct recruitment are already saturated. And thereafter there will be no direct recruitment. Even then, Lordship, they are recruiting. In the Lordship, I am referring page number Lordship 103, serial number 180. Page number 103, serial number 180. Morzina Khadun, date of engagement 28/4/2023. Again, Lordship, page number 98, serial number 26. It is after the advertisement 17/11/2022. Again, page number 103.
Just a moment.
Yes.
কিন্তু যেহেতু প্রফেসর কোনো মানুষ নাই এটা আরো বেশি একটু ডাইরেক্ট রিক্রুটমেন্ট করব Mr. Ahmed, your submissions are not taking us anywhere. You see, that's why we first asked Mr. Nath to explain what is he meant with that affidavit. You see, his reply was very precise and to the point. He says that the direct recruitment saturation has come. There is no dispute. He does not dispute that. Then he says that for further promotion, he is not getting appropriate candidate. And therefore, this has to be filled up by direct recruitment. So direct recruitment has to happen.
Okay. There are, Lordship, 20 posts, Lordship. Lordship, the vacancies which are arises, Lordship. The which are arises, they have to obtain the prior permission, and with the prior permission, they have to, Lordship, identify the vacancy, and then will have to apply, Lordship. And if the Lordship, the position already saturated, ratio 75% already saturated. So as per their stand, they cannot go for again direct recruitment because the 75% already saturated. That is why.
So you want that this essential function of the state should remain vacant?
No, Lordship. No, Lordship. That is why my humble submission that the procedure to determine the 75%, 25%, it should be existing vacancies. not from the entire ICDS project wise.
We can't accept that. We are always,
Lordship, my humble request, can you fix any another date?
no, after spending half an hour, 45 minutes, it's not another day.
No, then
Today is another day.
No,
That
Lordship,
another day is
yes,
today.
Lordship, I'm proceeding then. Yes. Because Lordship, there is no guideline they have to show that this will apply, Lordship, project wise. Because Lordship kindly my position is that because the all are 400 posts, the Anganwadi post is not.
We have given you enough opportunity. You see, number one,
Yes.
the learned single judge, when determining the matter,
Yes.
says that the policy of the state has not been under challenge, and therefore he says that the view of the state,
Yes.
that it is the total vacancy which has to be considered, and therefore the writ petition was dismissed.
No. The learned single judge held that the notification for Lordship, the 13 notifications, which was for the promotion, it was not challenged because I have known required to be challenged because whatever the notification is only for 25%. This notification does not say Lordship, it was project wise. Lordship, kindly come to that notification, Lordship.
It's at page 21.
Yes.
Oh, sorry, not that, not 21.
Page 45.
45. huh?
Yes, Lordship. Lordship. This Lordship, in partial motivation of this department's earlier notification number so and so, the government of Assam is pleased to inform all the concerned that the government of Assam in.
No, don't read everything.
Yes.
Just tell us the
Yes.
relevant.
Lordship, this notification specifically said that the notification of 2006 is strictly implemented with the same spirit and objects. And also the input notification, Lordship, yes, Lordship, and they also, Lordship, by their affidavit stated that it will implemented with the same spirit and objectives. Lordship.
Where is 1/3/2013 notification?
Lordship,
Where is 1/3/2013 notification?
1/3. No, Lordship, it was 4/3/2013, Lordship. 53 pages.
The second line in that notification says notification number so and so dated 1/3/2013.
Yes.
This notification has to be scrupulously followed.
Yes.
Where is that notification?
It is earlier, Lordship, in partial modification of earlier notification, Lordship. That is
Correct.
so and so.
So that's why it says the government of Assam so and so has welcomed the government of India's decision in
Yes.
right earnest and so it says. So it doesn't refer
Yes.
to which notification of the government is being referred to.
Yes, exactly, Lordship. Then Lordship come to page 47, Lordship.
Yes.
47, Lordship. 49, Lordship.
Yes.
49, paragraph number 2. That it is stated that the Ministry of Women and Child Development, Government of India requested the state and union territories to issue suitable instructions to reserve 25% of post of Anganwadi worker to be filled from amongst Anganwadi helper via their letter number 6/10/2006. And Lordship said, second paragraph, in pursuant to said letter, the government of Assam issued a notification, that is that notification, Lordship, to implement the decision of the same spirit with the same objectives to fulfill the condition as stated in the said notification.
Correct. So if according to you, they are not following this dictate, the notification of 4th March 2013 has to be assailed. You see, they are the employer. They think that this applies to the entire cadre strength.
Yes.
If they are the employer and they think so,
Yes.
and you say that it is not as per the guidelines,
Yes.
this notification has to be challenged.
No, so this notification Well, it is does not say that their lordship, it should be taken into project wise. There is no clause, lordship.
CDPOs are for project.
Lordship. ICDS project CDPO.
So if for some reason,
Yes.
let us say that there is a ICDS at Guwahati and there is an ICDS, what do you call this? Guwahati will have a large area. Let us say, for example, I'm just giving a horrible example. Guwahati has one CDPO. Guwahati has a very large area. Now, you forget about revenue village or you forget about the project. How will this CDPO work according to you? CDPO will work within his jurisdiction.
Exactly.
In his jurisdiction, if he has one Anganwadi center, he is a CDPO for one Anganwadi center. If it's a CDPO for 20 Anganwadi centers, he'll take into calculation all the 20 cadre strength of all the 20 Anganwadi centers. How do you think he should perform his duty?
Lordship, because a
Please tell us,
notification-
how does he perform his duty?
Because lordship, this is not my argument. Because the notification says itself says that this act should be done this way.
Serial number 10 says very simply, it shall be the responsibility of the CDPOs to determine the vacancies and advise
Yes.
them calling for the application.
Yes, lordship, that is why lordship.
It doesn't say application, it doesn't say application for each center.
Lordship, prior to lordship, lordship.
You see,
Yes,
there
lordship,
can't be
lordship,
25,
order.
there can't be reservation in each center.
To that regards, paragraph number 9 and 10, your lordship also passed an order prior to, lordship, prior to 23/5/2025, lordship, your lordship's order is there. Prior to 23/5/2025.
Which page?
Yes, lordship, the order sheet, lordship. Prior to 23/5/2025.
Which order?
Lordship, lordship, the before lordship 23/5/2025, lordship, I am.
23. Even that 23.
Please, yes.
You are referring to orders of this court?
Yes, yes.
Oh, that order is at page 63, order date is 6/3/2025.
Yes, yes.
So in that we made a query.
Yes, yes. Yes, lordship.
So they have responded to it and says that it's a entire cadre vacancy.
Yes.
Entire cadre strength, they are calculating 25%.
Yes, lordship, on that the lordship, it was observed, lordship, that this point is very specific, that one Anganwadi center, lordship, there should be the person who is to be recruited from that revenue village, lordship. So for different revenue village, Anganwadi worker cannot be, lordship, directly related to the original revenue village, lordship, original lordship center.
Just an, what do you call, a rough answer. Normally in a revenue village, how many Anganwadi centers would be there?
There is no fixed rule. If lordship kindly takes up the.
No, I'm just asking you.
To-
Let us say in this Guwahati,
It depends on the area.
in Guwahati, let us say we say this Ulubari revenue village.
Revenue village.
It's a large village.
Large village.
So how many Anganwadi centers would be here?
Exact figure I
You
don't
do not have.
But
Maybe
if-
one or two.
Lordship, if takes up
I'm
annexure
just giving a rough calculation.
one,
It would be one or two,
some five also,
somewhere five also.
Five also.
Now, Anganwadi worker is one
One.
in each center
Is
or more.
One.
One.
Oh,
How many Anganwadi helpers are there?
One.
One. So
One
workers are also one.
One helper, one
One.
worker.
So even if we take, let us say, even if there is 4 centers in each revenue village,
Smaller.
therefore 25 reservation would be only one.
But what happened, Lordship, just prior to that, let's suppose 4 centers are there. We don't know in which 4 vacancy will arise. Because if
No,
somebody
not on
resign-
that. I'm not on specifics. I'm just on a rough calculation.
out of four, suppose vacancy arose in 1, then 4 Anganwadi helpers, they will get the opportunity for
this one.
for this one.
Correct. And then if it is, if there are centers less than 4 in a village, then there would be no reservation.
But
25 can't be broken.
what happens? Therefore, total in the ICDS project total is 4. Suppose total is 4.
No, explanation will come later. I'm just asking us a rough arithmetic. What is the rule of reservation? If let us say 25 in a normal post where there's, let us say 33% reservation for women, or 10% reservation for, say, for various categories. You don't have, if it can't be broken up, then one. And if it is less than that, then there will be no reservation. It will be general, because they cannot be, the reservation cannot exceed the 50%. So therefore, it will be always 0 then. So we are just asking a rough calculation.
Kindly visualize this. Just I would submit one situation.
We will come to you. Just there's a query. For some reason, we have a query and just come back to you.
One situation has to be visualized, Millard. If suppose in center number 1 now the vacancy has arose, all the 4 helper will get the opportunity. Suppose subsequently after 2 months vacancy arose in center number 1 vacancy arose. 4 of them got the opportunity, but none has been selected. So vacancy remains. After 2 months, suppose in center number 3, the Anganwadi worker, she died or she left, resigns or something, vacancy arose. Then 25% is not filled up. So we have to out of 4, we have to again give the
No, we'll come to specifics. We asked you this question for a simple reason.
Lodge.
Yes.
So as per my humble submission, Lordship, this process was appreciated, Lordship. They are exceeded, Lordship, 25%. Even also they are exceeded 75% also, Lordship. They have taken pick and choose policy, Lordship. So, Lordship, this may be.
So, how do you say it is pick and choose?
Lordship, because
You see, you are not assailing any appointments. You are merely assailing the advertisement. So have you made pleadings about pick and choose?
Lordship, no, Lordship, I'm pleading is that 25% exceeded, Lordship.
We are in appeal.
Yes.
We can't hear something which is not pleaded before the single judge and not taken up as a substantive ground.
They violates the guidelines, Lordship, the 25%, 75%.
Okay. Yes.
But page 44 is the central government letter. This is a communication to all the states. This has ultimately, just for a moment, Malad, I'd like to take your Lordship to page 44. The Lordship has already read it, Malad. I'll just refer. The last paragraph. The state union territories are therefore requested to give a suitable instruction to all the authorities concerned with the implementation of the ICDS scheme in their state union territories to strictly follow the above guidelines. So there is a request to the state government to frame a guideline. Accordingly, page 45 has been framed. And Lordship has already taken note of serial number, guideline number 9 and 10. This is very specific. The promotion shall be, in fact, this is not promotion. This is up to, after a selection, it is upgradation. The promotion shall remain confined to the Anganwadi centers of the same revenue village, and as such, an Anganwadi helper of one revenue village or ward of a municipality or town committee cannot apply for promotion in the post arises in center falling in different revenue village or ward of a municipality or town committee. Secondly, the CDPO has been given the responsibility to determine the vacancies and advertise them, calling for application from the eligible Anganwadi helpers with prior permission of the Director Social Welfare Assam. But if Lordship takes up the list which we have annexed in the affidavit.
First of all, where is the advertisement?
Yes. It is at annexure 3 and 4 to the petition. Page number 32, Malab, in the writ appeal.
This is vacancy position, advertisement.
3 and 4, annexure 3, sorry, annexure 3 and 4.
36 is
Yes, 36, sorry. 36.
30?
Page number 36, annexure 3.
36.
Yes. This is the translated copy. Vernacular at page number 39.
Now, with this advertisement
Malab.
at page 36.
Yes.
Now, let us test the argument of both sides.
Yes, Malab.
Now, first is 69 number Shil Ghagri.
Shil Ghagri part 1.
And revenue village is Shil Ghagri part 1.
Part 1.
Correct.
Yes, Malab.
So, in this revenue village,
Lordship.
there is only one, apparently there's vacancy in one center.
In one
How,
center.
there may be many Anganwadi centers here in this revenue village.
Lordship.
Now, applicant will have to be Shil Ghagari part 1.
Shil Ghagri part 1.
Other revenue villages can't join.
No, Malab.
Do
Kindly now come to page number 98.
No, let us check in the net how many Anganwadi centers are there in this.
Lordship.
Shil Ghagri.
Yes.
Is that, can you check up in the mobile?
Lordship. এইখন মতে তো দুটা আছে ন এটা পাইছে
Shil Ghagri is not coming up.
revenue village.
So student should
Take it.
Lordship SIL, GHA, GRI.
SIL.
Yes. Because in the edition of the affidavit, page 198.
It's not coming.
Also, because in this page number 98, Lordship, it is written like so, Lordship.
No, whatever we are trying to check up how many
Yes.
how many centers are there.
Yes.
But
Is
in the list, from the list,
it will see SIL, GH, AG,
ZHAZRI. Well,
no, we have checked up with SIL also.
lot of
It's not coming up in the.
But
net search.
if I'm permitted to show from the list,
Yes, yes.
the list indicates that in the Silgagri part 1, the list contains 3 centers.
3 centers.
3 centers. Kindly take up page number 98. Serial number 2425. These are under Silgagri Revenue Village. Serial number 2425. This right hand side, second
Yes,
second
yes.
column, Silgagri part 1. And in the next page, serial number 32. This is also Silgagri Revenue Village.
37 also.
That is Silgagri part 2. These are revenue village different. Silgagri part 1. The revenue village name has been given. 3. And in serial number 32, Lordship will see the person concerned Anganwadi worker. She was there from 13/7/2007. In serial number 24, she was appointed on 14/3/23, and 25, she was upgraded on 17/11/2022.
So there is no case at all. If saturation point has reached, then there can't be any further reservation.
That
is precisely what you are trying to say.
For direct recruitment, petitioner is an intending candidate. Her case is that the advertisement for upgradation has to be cancelled, and 75% post has to be advertised for direct recruitment so that she can apply for that particular post. And one thing, Lordship, kindly take note, for a particular Anganwadi center only, survey area only, she can apply. If we tomorrow, in our affidavit, we have said that 10 advertisements we have to issue because the Anganwadi helpers suitable Anganwadi helpers are not there. Even if issue the advertisement, she may not be in a position to apply because she has to be from the concerned survey area. No, from the survey area. In direct recruitment is from the survey area. Only in case of upgradation, it goes to revenue area.
Okay, so it's a smaller area.
It's a smaller area. So if kindly takes up page 107, kindly for a moment, page take 107. There, kindly see serial number 339. Here just Garamari part 1. Garamari part 1 village has 5 centers. This is the revenue village. 1, 2, 3, 4, 5, 6 centers. 5 centers. Sorry, 5 centers.
330.
339.
339.
339, 340, 41, 42, and 43. These are all Garamari revenue village. Then 336, 337 also. 7 centers.
Yes.
So this particular revenue village has 7 centers. Suppose, a center number is 336 tomorrow, or tomorrow it fall vacant. Then we have to give opportunity to all the helpers of all the 7 centers.
So if they meet the criteria, they can be.
They can be upgraded. If they don't meet the criteria, then we have to go for direct. We have no option because we from other revenue village we cannot put someone.
Got it.
That aspect has been considered by the learned single judge in detail. If Lordship kindly takes off the judgment at page 85. we have explained that aspect in our affidavit at Annexure 2, which is available at page number 47. And that has been considered by the Honorable Court, my lord. From para 13 onwards, page 89. To make it short, kindly come to para 16. The notification dated 4/3/2013, having laid down the manner in which the promotion upgradation of Anganwadi helpers is to be effected, it is seen as to how the quota of promotion upgradation and direct recruitment against the post of Anganwadi worker is to be maintained. As per the procedure put in place for recruitment against the post of Anganwadi worker, 75% post is to be filled up by direct recruitment and 25% post is to be filled up by way of promotion upgradation. Said position was clarified in hearing by learned so-and-so by referring to the affidavit of the filed by the Secretary to the Government of Assam, Women and Child Welfare Department, by stating that the ratio of direct recruitment to promotion in respect of post of Anganwadi worker in ratio 75% is to 25% would be reckoned ICDS project wise. In other words, the said contention would go to mean that the post of Anganwadi workers existing within the ICDS project shall has to be filled up in the ratio of 75% by way of recruitment and 25% by way of promotion upgradation from amongst the Anganwadi helpers working in various Anganwadi centers under the said project. The guideline has laid down by the notification dated 4/3/2013, when read with the clarifications as contained in the affidavit so filed in the matter by the Secretary of the Government of Assam, so-and-so department, having demonstrated that the post of Anganwadi workers so existing within the ICDS project shall be filled up both by way of direct recruitment as well as by promotion upgradation in the ratio of 75% to 25% in absence of a specific challenge being made to the notification dated 4/3/2013. The challenge as made by in the present proceeding by the petitioner to the manner of recruitment as undertaken by notification dated 8/7/2022 and 18/7/2022 cannot be countenanced. The above conclusion having been drawn, the contention of the petitioner hearing that 20 vacancies having arisen against the post of Anganwadi worker in various Anganwadi centers under Gauripur ICDS project in terms of the decision of the Government of India, as contained in the communication dated 6/10/2006, only 25% of the said post being so permissible to be reserved for promotion upgradation of the Anganwadi helpers. The notification dated 8/7/2022 and 18/7/2022 would require an interference in as much as it reserves all the vacant posts even beyond the permissible 25% to be filled up by way of promotion upgradation of Anganwadi helpers is required to be so considered. The Secretary of the Government of Assam, Women and Child Development Department, in the affidavit had categorically contended that under Gauripur ICDS project there is in existence 400 Anganwadi centers, which would also mean the existence of 400 posts of Anganwadi workers. Accordingly, under the said ICDS project, 100 posts of Anganwadi workers is permissible to be so reserved for promotion upgradation of the Anganwadi helpers. It is also brought on record in the said affidavit that out of said 100 posts, only 21 posts have been so filled up by way of promotion upgradation of Anganwadi helpers, and accordingly further 79 posts of Anganwadi helpers is so permissible to be filled up by promotion upgradation of Anganwadi helpers. It has already noticed herein that the ratio between the direct recruitment and promotion upgradation against the post of Anganwadi worker is to be maintained ICDS project wise. The notification dated 8/7/2022 and 18/7/2022 having put up for recruitment of only 17 posts of Anganwadi workers, it has to be held that the same would be permissible given the fact that the quota as mandated for promotion upgradation against the post of Anganwadi worker in the ICDS project has not been fulfilled. So that has been categorically observed by the Honorable Court. And the specific challenge made by the petitioner is that you have to maintain 25%, 75%, as per the Government of India's later guideline of 2006 in each and every advertisement. In that case, the total figure will be different. We have to maintain out of the ICDS, the total number of posts available in the ICDS project, that has to be only in that case, only 75%, 25% can be maintained. Otherwise, each and every advertisement, if we go, then the upgradation and the direct recruitment figure will be different. In view of the conclusions reached herein above, and in absence of a challenge to the notification dated 4/3/2013, and the state having projected that the post of Anganwadi workers would be filled up both by way of direct recruitment as well as by promotion upgradation of Anganwadi helpers, this court is of the considered view that the contention as raised by the petitioner herein in the present proceeding in this connection does not merit acceptance. And kindly see, my lord, the grounds what they have taken in the writ appeal now. At page number 12 in the appeal. That is what basically their challenge. He is an intending candidate for direct recruitment, and this is the main ground, my lord, they have taken that for that the learned single judge has failed to appreciate the fact that as per notification dated 6/10/2006 issued by the Joint Secretary to the Government of India, Ministry of Social Welfare Department, 25% of posts of existing vacancies of Anganwadi workers are to be filled up by way of promotion, upgradation from amongst eligible Anganwadi helpers, and come to a wrong conclusion that 25% of posts of Anganwadi helpers are to be filled up by way of promotion, upgradation against total number of Anganwadi centers post under Gauripur ICDS project. That is his specific challenge. But even if my lord, 25, suppose my lord, we have advertised 20 posts. My lord, which 25% post, my lord, we will keep for promotion, and which 75% post out of in that advertisement we'll keep for direct recruitment, because we don't know, my lord, which Anganwadi center is going to be vacant tomorrow. Well, my humble submission is, Lord, that the vacancies are unforeseen, Lord. Now, as on today, since the 75% of direct recruitment is already, Lord, over, we have to meet for meeting up the 25% quota for upgradation of the Anganwadi helpers. Even today, the vacancies are not known, because the Anganwadi workers who are appointed directly are working now. If tomorrow some center vacancy arose in some center, then only we will get the opportunity to meet up the quota for upgradation. So in that way only we have to fill up. Otherwise, my lord, that 25% the notification of 2013 cannot be implemented. And the list which we have placed before your lordship, my lord, it was the point, my lord, in fact we have made out before the honorable court, and from the list annexed in our affidavit, we have shown that the direct recruitees are already in excess of 75%, and that has to be. Otherwise, even now also, my lord, in our affidavit we have said that in respect of 10 centers we have initiated the process for upgradation, but we could not fill up by upgrading them because they did not meet the qualification, the criteria. In that case, we have to go for new by direct recruitment. So this is the mechanism, my lord, in my responsible submission, my lord, as per the guideline, and the petitioner the challenge of the petitioner against the advertisement in question, my lord, has no merit at all, my lord. Therefore, my lord, the appeal needs to be dismissed.
Lordship, that one. Yes, Lordship, my learned friend is saying they don't know, Lordship, when the post will be vacant, who will be retired, Lordship. Page 45, Lordship, it follows 10, notification of 13. Page 45, point number 10. Yes. It shall be the duty of the CDPO to determine the vacancies and advertise them, calling for application from eligible helpers with prior permission of the Director of Social Welfare. It is his duty to determine the vacancies.
He's not saying no.
No, that should be.
Whenever
He's saying that it is not certain because only when the vacancy happens, then only they start the recruitment process. It is not like other statutory appointments where you know the vacancy is coming. You know that a person would retire on a particular day. For example, Rajya Sabha. They have 1/6 of the appointees retiring every year. So they know the vacancy and therefore the process of election or nomination of the next persons to become a Rajya Sabha member begins. Prior to that, this is not a institution like that where the.
Lordship, I may be wrong, Lordship, because the advertisement I have challenged, because the superannuation date was there, Lordship. There are 400 centers is there.
Yes.
It is easy for the Lordship, as per humble servant, easy for the CDPO to determine who will be retiring soon, Lordship. Because from the initial date of joining, because there is upper age limit is there.
For Anganwadi workers, they don't do that.
Subject to correction, Lordship.
No, it's not a subject of correction. It never happens because it's not a constitutional post. It's not a civil post.
Yes.
Once it is not a civil post, they are not likely to determine the vacancies which will come.
Yes.
These are only statutory vacancies which are considered in that way.
Yes.
It's not a post of director of education whose secondary education who's going to retire and therefore next man must come on the next day.
Yes.
So this is not a civil post. Supreme Court has said long back. Anganwadi workers and has not civil
one
post.
judgment I have got, Lordship, subsequently when the Lordship, the gratuity was, Lordship, just I have the judgment because the Food and Security Act, while Lordship came, it was held that it is a civil post. That judgment I have. Subsequent judgment.
Has the earlier judgment considered here?
Yes, Amerbi, Lordship, Amerbi was discussed.
Considered.
Yes.
Even then, the Lordship will see whether this submission is relevant to this present challenge or not.
We'll upgrade ourselves.
Yes. Paragraph number, Lordship, 17 and 18 I am referring. Page. Yes, Lordship. Internal page 780.
780.
Yes, Lordship. The decision in the case of Amerbi, Lordship. In that case, Lordship.
Yes.
Read, Lordship. In the case of Amerbi Supra, this court dealt with the issue whether Anganwadi workers and Anganwadi helpers were holding civil posts. The issue was whether the original application filed by the AO before the state tribunal established under the Administrative Tribunal Act 1985 were maintainable. This court held that post of Anganwadi worker were not statutory posts and the same have been created in terms of ICDS. Therefore, there is no relationship of employer and employee between the state government and Anganwadi workers. It was held that the Anganwadi workers do not carry on function of the state. It was observed that no recruitment rules have been framed for appointing Anganwadi workers. Mass water has fallen after the decision of Amerbi Supra was rendered in the year 2007. When the decision was rendered by this court, the Act of 2013, this is Lordship.
Yes, please continue.
Yes, was not on the statute book. As noted earlier, the Anganwadi centers established under ICDS have been given statutory status.
What is the 2013 Act?
13 Act, yes.
What is the 2013 Act?
Yeah, Lordship,
National Food Security Act.
Yes.
Yes.
And more so, under section 4, 5, and 6 of the Act, the Anganwadi centers perform statutory duties under 2013 Act. I have already referred to the government resolution of the government of Gujarat so and so. Page number, Lordship, paragraph number 17. The resolution incorporates, no, Lordship, this is not relevant. Paragraph number 18. In view of the provisions of 2013 Act and section 11 of the RT Act, Anganwadi centers also perform statutory duties. Therefore, even Anganwadi worker and Anganwadi helper perform statutory duties under the said enactments. The Anganwadi center have thus become an extended arm of the government in view of the enactment of 2013 Act and the rules framed by the government of Gujarat. Anganwadi centers have been established to give effect to the obligation of the state defined under Article 47 of the Constitution. It can be safely said that the post of Anganwadi worker and helpers are statutory posts.
Okay, it's good that you have brought this to our notice. We're not aware of it. Yes. As well as Mr. D. Nath, Leonard, Senior Government Advocate. Appearing for the state along with Ms. M. Das.
M. Devi.
M. Devi, okay. Leonard Counsel. Next, brother. By filing this intra-court appeal, the appellant, who's the writ petitioner in WPC 7502 of 2022 has assailed the dismissal of the writ petition by the learned single judge by judgment and order dated 8/8/2024. Next paragraph. The in the said writ petition, the appellant had prayed for setting aside and quashing of the two impugned advertisements dated 8/7/2022 and 18/7/2022 issued by the Child Development Project Officer within bracket CDPO for short, Goripur ICDS project, respond number 4, within bracket respond number 4. And for a direction to the respondent authorities to fill up vacancies in the post of Anganwadi workers by way of direct recruitment, keeping 25% reservation for promotion. Next paragraph. The appellant projects herself to be a higher secondary pass candidate and claims to be eligible for the post of Anganwadi worker in the direct recruitment process. The case of the appellant is that the two advertisements were specifically for upgradation of the promotion of Anganwadi helpers, of those Anganwadi helpers who had been in continuous service for more than 10 years. Out of 20 vacant posts, 17 were reserved for promotion from Anganwadi helpers to Anganwadi workers, leaving only 3 posts open for direct recruitment. Please correct me if I am wrong in facts. Next paragraph. The learned counsel for the appellant has submitted that the said recruitment process by the said two impugned advertisements violated the provisions outlined in a communication dated 6/10/2006 issued by the Ministry of Women and Child Development, Government of India, which envisages that only 25% of the posts for Anganwadi workers were required to be filled through promotion. And thus, the remaining 75% posts should be filled up through direct recruitment. Full stop. Referring to the notification dated 4/3/2013 issued by the Social Welfare Department, Government of Assam, it is submitted that the said notification provides guidelines to implement the herein before referred communication dated 6/10/2006, issued by the Ministry of Women and Child Development Department. Next paragraph. The learned counsel for the appellant has submitted that the said two advertisements violated the guidelines dated 4/3/2013, as well as the communication of the government of the Ministry of Women and Child Development dated 6/10/2006. You are for which ICDS project?
This Goripur ICDS project.
Goripur.
Yes,
Anganwadi Center.
Center Shilghagri, Lordship, 69 Shilghagri.
In the synopsis of the writ appeal,
Yes.
you have referred to Dharamshala ICDS project. What is that?
Goripur, that is Goripur, Lordship.
No, we don't know. You have written the Dharamshala. We are asking you that.
Yes, Lordship, it is Goripur Dharamshala, Lordship. It is already in the written, Lordship.
No, we don't know. If you write something in variance in the synopsis.
Lordship, kindly see page 35, Lordship.
No.
Yes.
Mr. Ahmed, please try to understand.
Yes.
We have this system of synopsis not for nothing.
Yes.
If you have to read everything, why we need a synopsis?
No, Lordship. It is, Lordship.
Page number?
Page number, Lordship. 35, Lordship.
35.
Yes, Lordship. The signature last portion, Lordship. শিশু উন্নয়ন প্রকল্প বিষয় সংগত শিশু উন্নয়ন সেবা প্রকল্প গৌরীপুর ধর্মশালা বসে
Goripur, Dharamshala.
Yes, Lordship, because Lordship, I put here Lordship only Dharamshala. I am sorry.
So Dharamshala would be
Please,
Huh?
Goripur ICDS project, Dharamshala.
Dharamshala. Okay. Goripur ICDS project, Dharamshala. Did not fulfill the required quota for promotion, upgradation, and thereby the advertisement for the 17 vacant posts of Anganwadi workers, was in violation of the established recruitment norms. Full stop. Therefore, as the learned single judge had upheld the recruitment process as being in compliance with the local ICDS projects projects requirements, the appellant being aggrieved by the said decision, has filed this intercourt appeal. Next, the learned counsel for the petitioner has referred to the grounds of appeal and has referred to the various annexures to the memo of appeal in support of his submissions. Full stop. The main thrust of submissions is to the effect that the clubbing of the entire cadre of Anganwadi workers and Anganwadi helpers in the ICDS project is erroneous, being contrary to the communication dated 6/10/2006 issued by the Ministry of Women and Child Development. First of all, he submits that the reservation of 25% for the Anganwadi workers should be from the vacancies which arise after notification dated 4/3/2013 and should not cover the entire cadre of Anganwadi workers and Anganwadi helpers. Correct?
Lordship, it should be, yes, it is implemented 2013 is.
Next paragraph. Per contra, comma, the landed senior government advocate by referring to the additional affidavit filed pursuant to order dated 23/5/2025, comma, had submitted that in the entire Gauripur ICDS project, comma, there are 400 posts of Anganwadi workers and equal posts of 400 Anganwadi helpers. Full stop. It is envisaged that each Anganwadi center would be having one Anganwadi helper and one Anganwadi worker respectively. Full stop. Accordingly, comma, it is submitted that 25% reservation in each center wise cannot arise, and therefore, as and the persons who are eligible to apply for upgradation to Anganwadi helpers should be confined only to those Anganwadi workers who hail from the same, who reside in the same revenue village. And therefore, persons from outside the revenue village in question cannot apply for their upgradation in an Anganwadi center as Anganwadi helper, comma, which is beyond the territorial jurisdiction of the concerned revenue village. Full stop. Accordingly, comma, it is submitted that that under the Assam, under the Anganwadi centers in Assam, comma, the appointment of CDPOs is not made revenue village wise. Stop. Therefore, comma, under the notification dated what is that? What 13?
Page 45.
4/3/2013, comma, it is envisaged that the %25 reservation is culled out from out of the total cadre strength of Anganwadi helpers under Gauripur ICDS project. Stop. Accordingly, comma, it is submitted that as the cadre strength of Anganwadi helpers is 400, comma, the upgradation can only be permissible for 100 posts. Full stop. It is also submitted that if a vacancy arises in a particular Anganwadi center and suitable candidates are not available for being upgraded from Anganwadi worker, to Anganwadi helper, such posts can only be filled up through direct recruitment. Full stop. Referring to paragraph 2 of the said additional affidavit, it is submitted that the specific stand of the additional director, Women and Child Development Department is that 75% quota of the Anganwadi workers, which is required to be filled up through direct recruitment, is already saturated. SATURATED. Full stop. It is submitted that presently 20 numbers of posts have been occupied by promotees, and altogether 335 numbers of posts of Anganwadi workers are being occupied by direct recruitees. Full stop. In respect of 45 existing vacancies at that point of time, in respect of Anganwadi workers, the competent authorities have taken the following steps. Violate 1. Proposals have been sent for approval to the Directorate Office is for 70 numbers of posts, semicolon. Number 2, proposal already sent for upgradation has been sent in respect of has been sent to the Directorate Office for 7 numbers of posts, semicolon. Number 3, new advertisement for direct recruitment after no eligible helper was found for upgradation is 10 numbers, semicolon. Number 4, advertisement for upgradation has been issued for 1 post, semicolon. New vacant positions are 10 numbers. Full stop. Accordingly, it is submitted that in order to effectively maintain the ratio of direct recruitment and promotees to 75% is to 25%, the total cadre strength of the Anganwadi workers are taken into consideration, which is subject to direct recruitment only when in respect of 25% reserve post only when suitable candidates are not available. Correct? Factually not factually correct. The saturated point is 75 or 25? What did I say? It should be 75%, not 25. 75, no? Okay. Next problem. The learned single judge, having considered the notification dated 4/3/2013, had accepted the contention of the state that in respect of the posts of Anganwadi worker, comma, in the ratio of 75% is to 25%, comma, would be so reckoned, 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 ICDS project wise. Full stop. Moreover, comma, after analysis of the materials available on record, comma, the learned single judge had also held that the post of Anganwadi worker existing within an ICDS project is required to be filled up both by way of direct recruitment as well as by way of promotion or upgradation in the ratio of 75% is to 25%. Therefore, comma, in absence of any specific challenge being made to the notification dated 4/3/2013, comma, the learned single judge had held that the challenge made in the present and in the writ petition as to the manner of recruitment being undertaken by notification dated 8/7/2022 and 18/7/2022 cannot be countenanced. COUNTENCD. NENCD. Countenanced. Stop. Accordingly, comma, the reasoning of the learned single judge that the notifications, that the advertisements dated 8/7/2022 and 18/7/2022 being for recruitment of 17 posts of Anganwadi workers was held to be permissible as the mandated promotion of the upgradation against the post of Anganwadi worker in the ICDS in the Gauripur ICDS project has not been fulfilled. Next paragraph. Having considered the submissions made by the learned counsel for the appellant, as well as the submissions in reply made by the learned senior government advocate, the court is of the considered opinion that insofar as the notification number SWD full stop 107/2007/81 dated 4/3/2013, issued by the Social Welfare Department, Government of Assam, having given the responsibility to the CDPOs to determine the vacancy and advertise them, calling for applications from eligible Anganwadi helpers, with prior permission of the director, Social Welfare, Assam, the vacancies. Now, the vacancies to be filled up would be relatable to the cadre strength within the jurisdiction of the concerned CDPO. Full stop. The court is unable to accept the contention of the learned counsel for the appellant that the cadre strength could be bifurcated to mean cadre strength which existed prior to 4/3/2013 and cadre strength an additional cadre strength which came into existence on and from 4/3/2013. Full stop. Therefore, the reservation envisaged for the Anganwadi helpers to the extent of 25% as envisaged by the said notification dated 4/3/2013 must be calculated on the basis of the cadre strength under the Gauripur CDPO, Gauripur ICDS project. Full stop. Therefore, as the stand of the state is that the 75% quota of the Anganwadi workers, which is required to be filled up through direct recruitment, is already saturated. The court is inclined to accept the contention of the learned senior government advocate that if suitable persons are not found to fill up the 25% certain persons from Anganwadi workers are not found to fill up the quota for upgradation of the promotion. Only then those posts can be filled up by way of direct recruitment. Next, but under such circumstances, comma, we find no reason to take a view different from the one taken by the learned single judge. Just according to this, intercourt appeal fails and the same is, and this appeal is, intercourt appeal is dismissed. Next, but under this circumstances, we leave the parties to bear their own cost. There was one matter we wanted to take it up, upgrading. Which matter? 30.
See, the notice which was hung up that item that will be taken at 2 p.m.
But we not have time today. This criminal writ petition, item 30.
Yes, that is habeas corpus petition. Your lawsuit directed the government advocate whether after completion of 3 years they can again be put behind the bar. And as per
Mr.
the
Nath, I think here you will have to.
My lord, here this Honorable Supreme Court's order is very much clear that a declared foreigner. So
This is that criminal writ petition.
Yes.
Yes.
Where the question is whether he can be again taken into custody for the purpose of deportation.
Lordship, in item number 7, Lordship, I have filed one affidavit in the light of same stand we have to take in the others cases also, Lordship.
No, because this is once it is under challenge and they are referring to the Supreme Court judgment, you better file an affidavit here also.
Lordship.
Since you already have an affidavit ready, file it within this week so that we
Yes,
can take it up next week.
Yes, Lordship. Yes, sir.
Or because here there is a specific query, or that affidavit will cover it or not, I don't know. Because he says that Mr. Mahmood is relying on that Supreme Court judgment.
Yes, Lord.
Of granting bail to those persons who were in detained.
Lordship, during COVID period.
During COVID.
Yes, Lord.
after declaration of foreigner, COVID
we
is not
understand?
connected.
Yes, Lordship.
No. After declaration, that bail was granted only for COVID.
Yes, Lord.
The order does not say like this. man.
Yes, it is.
May I read the relevant portion?
Where you are reading?
That is the order. It's an order dated 13/4/2020, passed in suo motu writ petition civil number 1 of 2020.
Yes, 13/4/20. Please read.
Having regard to the present circumstances prevailing in the country and having regard to the fact that we have already permitted.
Oh, no, don't start reading from in between. Because in the first case, it is IA 48260. There, the direction was in connection with COVID.
Yes.
Page 3. It starts with COVID and
Second
then.
part, my lord.
No, it's not a question of part. Supreme Court orders can't be dissected and read in isolation.
No,
At least we have.
One was the.
No, whatever has happened, we don't know, but we have not learned to dissect a Supreme Court judgment and then read it paragraph wise. All the matters are taken up in common. And
people
and
are in
the
detention
initial-
in general, that's what are there.
We are reading which paragraph?
The last paragraph. So, the first thing was that was COVID, no doubt, but thereafter, Lordship, it is said that and having regard to the fact that we have already permitted the release of prisoners and people under detention in general, and such detainees who have completed 3 years upon their declaration as foreigners, we see no reason why the period should not be reduced from 3 years to 2 years, That is to say, the prisoners or detainees who have been under detention for 2 years shall be entitled to be released on the same terms and conditions as those laid down in the aforesaid order dated 10/5/19, except that they shall not be required to furnish a bond in the sum of rupees 1 lakh. Instead, they shall be required to furnish a bond in the sum of rupees 5,000 with 2 local sureties. So here 2 years have been made, and bail amount has been reduced to 1 lakh to 5,000 rupees with 2 local sureties. So I have completed more than 3 years. Again, I have taken into custody. And another question, my lord, by filing affidavit, case cannot be improved. There are Supreme Court judgments, so many judgments. By filing affidavit, case cannot be improved. Only they may bring the facts, but the order of the Honorable Supreme Court cannot be bifurcated by filing affidavits.
You will consider that when they file it.
Yes, sir.
Can you say that you can preempt somebody from filing an affidavit?
No, no, that
No.
it is that
No, Mr. Mohammed, at least from you, we don't want that,
it is their discretion.
submissions.
But
No, it's not a discretion, it's a right. In a litigation, a party has a right to file an affidavit. It's not a discretion. And the court can compel. We have powers, not only inherent powers of the court under Article 226, but we can compel any affidavit to file by any authority in a writ petition. We are beyond boundaries when we exercise our extraordinary jurisdiction.
But if they do not file, then the court will pass adverse order. That is also there.
Well, then, so you file it within Friday, we take it up on Wednesday.
Yes.
Correct? All sides are represented. Mr. G. Sharma, Honorary Standing Counsel for the FT matters, prays for some time to file an affidavit in the matter. Full stop. Prayer is allowed. The affidavit in opposition, comma, if the state so desires, comma, be filed within. Saturday is also a working day this time, within 19/7/2025. With copy thereof to the Learned Counsel for the petitioner. Next, we'll list the matter again on 23/7/2025. We'll have to rise for the single bench. Item 13 was there. Item 13, who is there? We'll take it up on Wednesday because this week is too hectic for us.
Item 24 is date may be given. Item 24. I'm not
No,
on bail.
we'll fix it thereafter because we don't have, this week is too hectic for us. Too many things are happening together. This matter item number 13, we are fixing it on Wednesday. Others, the court master will take care.
Yeah, please, your lordship.
Yes.
I have item number 36. I have for bail application. The petitioners in.
You can't take up today. The court master will adjust.